Good evening, everybody. If you are coming in, we're going to be talking about Caetano v. Massachusetts. Now, this is actually a really easy holding. It's not an oral argument. It's just a per curiam holding with the concurrence by Alito, which I will read out to you. But I kind of want to start this off a little differently because I found this really, really interesting, and I don't know if anybody else will. So something I had kind of wanted to talk about was this article I saw today, and it says they posted it like 6 hours ago. A House member's chief of staff charged with carrying a gun into U.S. Capitol complex. Sorry, guys, I'm still have a cold. So I found this article really interesting. The chief of staff for Representative Pete Sessions, a Texas Republican, was charged Wednesday with bringing a firearm into the U.S. Capitol complex. I apologize, guys. According to court documents obtained by CNN. Luis Angel Vega appeared in D.C. Superior Court Friday on the charges which stem from an alleged incident in December. Vega faces 2 counts: carrying a gun outside his home without a license and carrying a firearm onto Capitol grounds. And I need just everybody, can you keep up with me for 1 second? I remember there being, it's like 5 to 10 specific firearm related charges in relation to J6. They were pardoned. Those motherfuckers were pardoned. And this from the party that just fuck metal detectors, and largely more of them are like everybody should carry. I find this to be such an odd thing that we're charging him. So Vega faces 2 counts: carrying a gun outside his home without a license and carrying a firearm onto Capitol grounds. He was handcuffed and his white button-down shirt was untucked. A judge released him without setting bail. In December, Capitol security officers, and this is the best part of the story. This is the part of the story that just kind of makes you go, what the fuck? In December, Capitol security officers found the black pistol and ammunition Vega allegedly carried when he sent his bag through a security checkpoint at the entrance of the house, of a house office building that's a part of the Capitol complex. And I promise I'm going to be getting into Caetano after this, but this is kind of just a weird thing that I saw that I wanted to read off to everybody. The court documents said, then they instructed Vega to lock up the firearm in his car and return for his bag to be rescreened, which he did according to the filings. The charging documents describe a telephone interview that U.S. Capitol Police conducted with Vega a week after the alleged December 22nd episode. They instructed him to take it to his car, and I understand things happen, whatever, it's a forgetful situation. I'm not saying these things shouldn't be taken seriously, but I'm saying he's a worker there. He obviously likely forgot that it was on his person, and he returned it to his vehicle with no hesitation, at least from what we know right now. Charging documents describe a telephone interview with U.S. Capitol Police conducted with Vega a week after the alleged incident. Vega told the police officer that he did not have a license to carry the pistol, according to the court filing. I'm guessing that's a D.C. license, and that he usually enters the House building with Sessions, referred to as Witness 1 in the documents, who is exempt from being screened by the MAC. Okay, so let me get this straight. If you're a House member, you can just roll up in there and you don't need any sort of screening. You're nothing. But this guy, I just find that so odd. The day of the offense was out of the ordinary in that Witness 1 entered the building separately from the defendant, and the defendant forgot there was a pistol in his bag. I mean, likely he's brought it in before, but again, if you're letting him enter with people who aren't screened, then that's a failure of Capitol security. Just saying. Hi, everybody coming in. I can't see comments very well right now. I promise I am trying to read them, but I'm almost done with this story. It is not clear why the warrant for Vega's arrest was issued months after the incident, prompting his first court appearance set for Friday. CNN reached out to Sessions' office for comment. A lawyer for Vega has not been identified. U.S. Capitol Police didn't immediately return requests for comments. The U.S. Attorney's Office declined to comment on Friday on its decision to charge the case. Okay, so we're going to come back. We're going to come back again. U.S. Attorney said, we're going to file this. I don't know. I found that like the height of fracking irony. I don't know if anybody else is here with me on this, but I just felt it to be weird. So Caetano is actually a super short case. There's not really there's no oral argument on this. What there is a per curiam decision. It's 9-0 with a concurrence by Alito. As long as the Alito concurrence isn't like 30 pages long, and sometimes they do get fucking mouthy, I can go through this rather easily. And then I kind of want to talk about it because we're talking about building on previous cases here. This is the whole point of what I'm doing. How do cases build? How does case law build? And where do we see these outcomes? How does it affect other cases going forward? So far we've done Heller and we've done McDonald. Those are two foundational. One says, hey, the Second Amendment, we apply that to the state through the due process clause, which is McDonald. And then Heller says, the right to bear arms, isn't tied to militia service. So we're going to get into Caetano, which actually deals with tasers. If you don't know, many states have rather restrictive, stun guns. I apologize. I'm sure there's a difference, and I couldn't articulate to you what it is. But regardless, they're both shocky. But it deals with a lady... I think it's, Jamie Caetano. And it deals with her having a taser and an ex-boyfriend. And I'll read you a little bit of the background on the case. And then we'll kind of go into it. 1 second. Oh man, I had some background pulled up I wanted to read, but essentially ex-boyfriend issue, all the things. As always, I'm very pro, even if you don't want to carry an arm, which is totally and completely freaking valid, at least, please protect yourself out there, even if it's just a self-defense class. Make sure that you're okay. But anyway, so Caetano v. Mass, super short per curiam decision. The court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. This is talking about the in common use that comes from DCV Heller. So I talked a little bit about that. I told y'all to pay special attention to the in common use provision, and this comes into play here. And that this Second Amendment right is fully applicable to the states in McDonald v. Chicago. In this case, the Supreme Judicial Court of Massachusetts upheld a Massachusetts law prohibiting the possession of stun guns after examining whether a stun gun is a type of weapon contemplated by Congress in 1789 as being protected by the Second Amendment. And I want you to really listen to the words they're using here. This is going to take us into some of our text history and tradition that we're going to be looking at with Bruin. This will be, we're looking at how these carry forward and affect other cases. And I'm going to say this is a direct relation? No, but I'm saying pay attention to the words they're using here. Whether a stun gun is the type of weapon contemplated by Congress in 1789 as being protected by the Second Amendment. Okay, so this is an argument we also see when people are talking about, and this is just things I hear people, when people are talking about AR bans and stuff, they're like, well, they didn't have that at the founding. Now, is this the best level argument people make? Absolutely not. But this is also something that you have to consider moving forward that they might harken back to. So anyway, the court offered 3 explanations to support its holding that the Second Amendment does not extend to stun guns. First, the court explained that stun guns are not protected because they were not in common use at the time of the Second Amendment's enactment. This is inconsistent with Heller's clear statement that the Second Amendment extends to arms that were not in existence at the time of the founding. The court next asked whether stun guns are dangerous per se at common law and unusual. In an attempt to apply one important limitation on the right to keep and bear arms, referring to historical tradition of prohibition, the carrying of dangerous and unusual weapons. In so doing, the court concluded that stun guns are unusual because they are a thoroughly modern invention. By equating usual with in common use at the time of the Second Amendment's enactment, the court's second explanation is the same as the first. It is inconsistent with Heller for the same reason. And then finally, the court used a contemporary lens and found nothing in the record to suggest that stun guns are readily acceptable to use in the military, but Heller rejected this proposition. That only those weapons useful in warfare are protected. So already you're kind of seeing some like threads pulling here. Only arms that are useful in warfare are protected. I'm wondering if that's in connection with militia service. I'm wondering where that kind of like line is that they're drawing. For these three reasons, the explanation the Massachusetts court offered for upholding the law contradicts this court's precedent. Consequently, the petition for a writ of certiorari and the motion for leave to proceed in forma pauperis are granted. The judgment of the Supreme Judicial Court of Massachusetts is vacated, and the case is remanded for further proceedings not inconsistent with this opinion. Let's look at what Alito said. Let's see. Alito, with whom Thomas joins, concurring in the judgment. Okay, let's see what we got. Give me 1 sec. I'm so sorry. And if you are requesting, I cannot see my request box, so my bad. But anyway, after a bad altercation with an abusive boyfriend put her in the hospital, Jamie Caetano found herself homeless and in fear of her life. She obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, Caetano accepted the weapon. It is a good thing she did. One night after leaving work, Caetano found her ex-boyfriend waiting for her outside. He started screaming that she was not gonna work at this place anymore because she should be home with the kids they had together. Caetano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. But she didn't need physical strength to protect herself. She stood her ground, displayed the stun gun, and announced, "I'm not going to take this anymore. I don't want to have to use this stun gun on you, but if you don't leave me alone, I'm going to have to." Gambit work. Then the ex-boyfriend got scared and left her alone. It is settled that the Second Amendment protects an individual right to keep and bear arms that applies against both the federal government and the states. District of Columbia v. Heller and McDonald v. Chicago. That right vindicates the basic right of individual self-defense. Caetano's encounter with her violent ex-boyfriend illustrates the connection between those fundamental rights. By arming herself, Caetano was able to protect against a physical threat that restraining orders had proved useless to prevent. And commendably, she did so by using a weapon that posed little, if any, danger of permanently harming herself or the father of her children. Under Massachusetts law, however, Caetano's mere possession of the stun gun that may have saved her life made her a criminal. When police later discovered the weapon, she was arrested, tried, and convicted. The Massachusetts Supreme Judicial Court affirmed the conviction because holding that a stun gun is not a type of weapon that is eligible for Second Amendment protection because it was not in common use at the time of the Second Amendment's enactment. This reason defies our decision in Heller, which rejected as bordering on the frivolous the argument that only the arms in existence in the 18th century are protected by the Second Amendment. The decision below also does a grave disservice to vulnerable individuals like Caetano, who must defend themselves because the state will not. Oh, geez, I was making sure my mic was on. I was like, I hope I'm not talking this whole time. Yeah, so this is a per curiam ruling. So if you're joining, I apologize. We're talking about a case called Caetano v. Massachusetts, in which a woman who was a victim of abuse had a stun gun, and Massachusetts said, nah, bitch, you can't have that. And then their what is it called? Their Supreme Judicial Court, blah, 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 said, well, it's not protected because it's not an arm that's protected by the Second Amendment. And this is why these cases are important. I know, like, I got a lot going on because I got kiddos and stuff, but, like, here's the thing. When we talk about this and we're talking about how we're building on case law, Heller was a fundamental case here. We looked at Heller, we looked at McDonald v. Chicago, and these have come up multiple times in both what we've talked about with the per curiam ruling and also this concurrence we're reading through with Alito. This case law matters. And listen, I can appreciate that everybody comes from a different position on this. I have my own position, y'all have yours, and that's fine. Like, I'm not hating on that at all. What I am saying, though, is we have to look at, because this is a fundamental point that came out of Heller that I told everybody to pay attention to, and this is why I want to, like, harken back to it, is sort of the in common use. Just because it wasn't around at the founding, Caetano has already told you they don't care about that. That's not the only protected arms. So it takes away from some of that. And these aren't the best arguments that are made, but some people make these shit arguments that, well, they weren't around at the founding, so it can't be protected. No, that's fundamentally fucking untrue. That is not how it works. And I think this says a lot, particularly in where we may go with bans on certain types of firearms. Again, I can't read tea leaves. That's not my job. The best I can do is maybe offer you an educated guess. But yeah, so this is a really interesting case. And let's get back into reading Alito's concurrence. The events leading to Caetano's prosecution occurred sometime after the confrontation between her and her ex-boyfriend. In September 2011, police officers responded to a reported shoplifting at Ashland, Massachusetts supermarket. The store manager had detained a suspect, but he identified Caetano and another person in the parking lot as potential. Let me say this again. Potential accomplices. It doesn't say definitely accomplices. It doesn't say they said they have them on video. Like, it says none of this. It says potential accomplices. So police approached the two and obtained Caetano's consent to search her purse. Never give consent. Make them get a warrant. And this is not legal advice. This is just me being your friend. Make them get a fucking warrant. Anyway. So let's see. He identified Caetano and another person of potential accomplices. Police approached to obtain Caetano's consent to search her purse. They found no evidence of shoplifting, but saw Caetano's stun gun. Caetano explained to the officers that she had acquired the weapon to defend herself against a violent ex-boyfriend. The officers believed Caetano, but they arrested her for violating Massachusetts General Law, Chapter 140, which bans entirely the possession of an electrical weapon. When Caetano moved to dismiss the charge on Second Amendment grounds, this is where it comes back up. on Second Amendment grounds. She's like, no, these are protected armed, da 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 da. Like, you can't do this. The trial court denied the motion. A subsequent bench trial established the following undisputed facts. The parties stipulated that Caetano possessed the stun gun and that the weapon fell within the statute's prohibition. The Commonwealth also did not challenge Caetano's testimony that she possessed the weapon to defend herself against the violent ex-boyfriend. Indeed, the prosecutor urged the court to believe the defendant. The trial court nonetheless found Caetano guilty. She appealed to the Massachusetts Supreme Judicial Court. Oh, thank you so much, guys. If you're watching and tapping and liking, I appreciate you all so much. This will be a quicker live than most of the ones I do, but I will put it over to YouTube if you're just halfway through and want to know more. So the Supreme Judicial Court rejected Caetano's Second Amendment claim, holding that a stun gun is not the type of weapon that is eligible for Second Amendment protection. The court reasoned that stun guns are unprotected because they were not in common use at the time of the enactment of the Second Amendment, and because they fall within the traditional prohibition against carrying dangerous and unusual weapons. No, they don't, but okay, let's go off. Although the Supreme Judicial Court professed to apply Heller, each step of its analysis defied Heller's reasoning. The state court repeatedly framed the question before it as whether a particular weapon was in common use at the enactment of the Second Amendment. In Heller, we emphatically rejected such a formulation. We found the argument that only those arms in existence at the 18th century are protected by the Second Amendment not merely wrong, but bordering on frivolous. Instead, we held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. It is hard to imagine language speaking more directly to the point, yet the Supreme Judicial Court of Massachusetts did not so much as mention it. Instead, the court seized on language originating in U.S. v. Miller. Miller is our sawed-off shotgun case that came up quite a bit in Heller. It was kind of the one case that really D.C. was kind of pulling. The sorts of weapons protected were those in common use at the time. That quotation does not mean, as the court below thought, that only weapons popular in 1789 are covered by the Second Amendment. It simply reflects the reality that founding era militia consisted of citizens who would bring the sorts of lawful weapons that they possessed at home to militia duty, and that the Second Amendment accordingly guarantees the right to carry weapons, typically possessed by law-abiding citizens for lawful purposes. Listen to that again. Typically possessed by law-abiding citizens for lawful purposes. While stun guns were not in existence at the end of the 18th century, the same is true for weapons most commonly used today for self-defense, namely revolvers and semi-automatic pistols. Revolvers were virtually unknown until well into the 19th century, and semi-automatic pistols were not invented until near the end of that century. Electronic stun guns are no more exempt from the Second Amendment protections because they were unknown to the first Congress than electronic communications are exempt from the First Amendment, or electronic imaging devices are exempt from the Fourth Amendment. Listen, I can hate on Alito all day, and he's like the bane of my existence, but the man can do a damn good comparison. Like, he just has some bangers from time to time and stuff he writes. If you are coming in, I promise, like, I can't see everything because I'm reading the Alito concurrence in this, so I promise I will get to you as soon as I can. As Heller aptly put, we do not interpret constitutional rights that way. The Supreme Judicial Court of Massachusetts holding that stun guns may be banned as dangerous and unusual weapons fares no better. As the per curiam opinion recognizes, this is a conjunctive test. A weapon may not be banned unless it is both dangerous and unusual. This is why I want us to focus up here in sort of what I was talking about. We're hearkening back to other cases, but I want to look at cases we could foresee coming before the Supreme Court in the next couple of years. I think we're going to probably see mag bans, probably going to see AR bans. I think that is going to be a likely reality of something this court is going to want to visit. So I want to read this to you again, and I want you to understand. It can be just dangerous and not unusual, or it can be unusual and not dangerous. But the conjunctive test is it has to be both dangerous and unusual. There's a lot of prospective bans and bans that are already in place that, while a lot of people like to think, particularly with AR bans, are probably the best example of this, right? And however you may feel, I'm just asking you to hear me out. This is not a me thing. This is just I'm talking to you about it. ARs are the most commonly used rifle in America. They are dangerous, but not unusual, and they have to reflect both, according to what is affirmed in this per curiam opinion, and they're reaffirming they're hearkening back to Heller and the in common use. So a weapon must not be banned unless it is both dangerous and unusual. So like a nuke, right? It is both dangerous and unusual. It's not something that people commonly have, right? So effectively, I could see banning people from owning, that's a reasonable ban. But when you're talking about one of the most commonly used weapons in the US, unfortunately, I don't know that ban's going to fare well. And I think based on what we see here, we could kind of see that coming. So because the court rejects the lower court's conclusion that stun guns are unusual, it does not need to consider the lower court's conclusion that they are also dangerous. Yes, so because the court rejects the lower court's conclusion that stun guns are unusual, because they're not. They're very readily found. This is a 2016 case, same at the time. They sold them at gas stations where I worked. So or maybe, I don't know, stun gun, at least taser. Let's say they're both shocky. We'll say they're shocky, right? But you could buy tasers at gas stations here. I'm in Texas, but either way, stun guns are not unusual. It does not need to consider the lower court's conclusion that they are also dangerous. Weapons are by definition dangerous, but they usually are going to have to meet that unusual principle, which is where we come into the issue here. As far as I know, just shock. They didn't do a descriptor, so I would have to go pull her stuff. But make no mistake, the decision below gravely erred on both grounds. As to dangerous, the court held that the weapon is dangerous per se if it is designated to construct or produce unaliving or great bodily harm, and for the purposes of bodily assault or defense. The test may be appropriate for applying statutes criminalizing assault with dangerous weapon, but it cannot be used to identify arms that fall outside of the Second Amendment. First, the relative dangerousness of a weapon is irrelevant when the weapon belongs to a class of arms commonly used for lawful purposes. In common use, just write it into your brain. Sorry, I lost my place. In common use for lawful purposes, contrasting dangerous and unusual weapons that may be banned or with protected weapons in common use at the time. Secondly, even in cases where dangerousness might be relevant, the Supreme Judicial Court's test sweeps far too broadly. Heller defined arms covered by the Second Amendment to include and to include anything that a man wears for his defense or takes into his hands or useth in wrath to cast or strike another. Oh, gotta love Scalia wordplay. Anyway, under the decision below, however, virtually every covered arm would qualify as dangerous. That's what I just told y'all. Like, I think the inherent point of a weapon is likely to be dangerous, or that it can be dangerous if used in the right manner. It's the unusual portion that people fail to meet a lot. Dude, redacted, shut up. Anyway, whether there's any doubt on this point, one need only look at the court's example of dangerous per se weapons, firearms. If Heller tells us anything, it is that firearms cannot be categorically prohibited just because they are dangerous. A Faturi stun gun. Wait, I read that. Is that a Faturi? It doesn't matter. Stun guns that the Commonwealth own witness described as non-lethal force cannot be banned on that basis. The Supreme Judicial Court's conclusion that stun guns are unusual rested largely on its premise that one must ask whether a weapon was commonly used in 1789. As already discussed, that's simply wrong. The court also opined that a weapon's unusualness depends on whether it is a weapon of warfare to be used by militia. Let me be clear. Heller sort of separated that sort of claim of, like, in order to do this, it has to be related to militia service. That was a big part of what Heller did. So right here, you're already kind of seeing the whole, well, it's militia, you're seeing that coming back up. Maybe not in the same way, but you're seeing it coming up in a similar way. Hold on, I'll try to answer. Sorry, I could barely read comments, so I apologize if I'm missing you. I'm not trying to. It's A space FORTIORI. And I can't see if I have guest requests, so I promise I'm going to get to you. Just give me a minute. Let's see. Court also opined unusualness, but asserted that we followed such an approach in Miller, and it. Okay. The court also opined that a weapon's unusualness depends on whether it's a weapon of warfare by militia. It asserted that we followed such an approach in Miller and approved its use in Heller. But Heller actually said it would be a startling reading of Miller to conclude that only those weapons useful in warfare are protected. Instead, Miller and Heller recognized that militia members traditionally reporting for duty carrying the sort of lawful weapons that they possess at home, and that the Second Amendment therefore protects such weapons as a class, regardless of any particular weapon's suitability for military use. Indeed, Heller acknowledged that advancements in military technology might render many commonly owned weapons ineffective in warfare, but such modern developments cannot change our interpretation of a right. In any event, the Supreme Judicial Court's assumption that stun guns are unsuited for militia or military use is untenable. Section 131J allows law enforcement and correctional officers to carry stun guns and tasers, presumably for such purposes as non-lethal crowd control. Subduing members of a mob is a little different from suppressing insurrections, a traditional role of the militia. Additionally, several branches of the U.S. Armed Services equip troops with electrical stun weapons to incapacitate a target without permanent injury or known side effects, except for if you're older millennial and then you're going to piss yourself. Sorry, I had to throw that one in, y'all. Anyway, As the foregoing makes clear, the pertinent Second Amendment inquiry is whether stun guns are commonly possessed by law-abiding citizens for lawful purposes today. The Supreme Judicial Court offered only a cursory discussion of that question, noting that the number of tasers and stun guns is dwarfed by the number of firearms. This observation may be true, but is beside the point. Otherwise, a state would be free to ban all weapons except handguns, because handguns are the most popular weapon chosen by Americans for self-defense in the home. The more relevant statistic is that hundreds of thousands of tasers and stun guns have been sold to private citizens who, it appears, may possess them in 45 states. Hold on, I'm sorry, guys. While less popular than handguns, stun guns are widely owned and accepted as legitimate means of self-defense across the country. Massachusetts' categorical ban of such weapons therefore violates the Second Amendment. Oh my God, I just saw that. I can't stop being Colorado. Sorry, I'm sorry. Forgive me, but that was funny shit. The lower court's ill treatment of Heller cannot stand. The reasoning of the Massachusetts court poses a grave threat to the fundamental right of self-defense. The Supreme Judicial Court of Massachusetts suggested that Caetano could have simply gotten a firearm to defend herself, but the right to bear other weapons is no answer to a ban on the possession of protected arms. Moreover, a weapon is an effective means of self-defense if one is prepared to use it, and it is presumptuous to tell Caetano that she should have been ready to shoot the father of her two young children if she wanted to protect herself. Courts should not be in the business of demanding that citizens use more force for self-defense than they are comfortable wielding. I really agree with this position. It's something that I come back to a lot. I didn't know was said here. This is a fresh reading for me, just like it is for you. I'm trying to tie in some of the previous cases we've looked at, but here's what I kind of want to reinforce. I would not want anybody to be forcibly armed. I think that can be very dangerous even as somebody who's just out there like on the loose. Forcible arming is never something I think is a good practice, because if people are uncomfortable, they're more likely to make a mistake. And I think he said something really important there, in as much as I like dog shit Alito, that was a really important thing to say. Countless people may have reservations about using deadly force for moral, religious, or emotional reasons, or simply out of fear of killing the wrong person. See brief for arming women against rape and endangerment. Self-defense, however, is a basic right. I am not prepared to say that the state may force an individual to choose between exercising a right and following her conscience, at least where both can be accommodated by a weapon in widespread use across the nation. I will be really, really real with y'all. I don't understand the states that have like really stringent like rules on tasers and shit like that. I think they're overall likely a safer option. Now, things could go wrong. I'm not saying you could piss yourself. People have heart issues, can also have issues. But I'm saying overall, if it's freedom seeds or a taser, I'm probably going to take the taser, right? But it's incapacitating for at least a small amount of time to allow somebody to flee. I think I don't understand states like fucking issue with that. I know a few states like require you to basically have the same licenses. But a state's most basic responsibility is to keep its people safe. The Commonwealth of Massachusetts was either unable or unwilling to do what was necessary to protect Jamie Caetano, so she was forced to protect herself. To make matters worse, the Commonwealth chose to deploy its prosecutorial resources to prosecute and convict her of a criminal offense for arming herself with a non-lethal weapon that may well have saved her life. The Supreme Judicial Court of Massachusetts then affirmed her conviction on the flimsiest of grounds. I think that these people did not even read Heller. They didn't read McDonald. They definitely didn't read Heller. Like, it's crazy shit. But anyway, this court, grudging per curiam, now sends the case back to that same court, and the consequences for Caetano may prove more tragic still, as her conviction likely bars her from ever bearing arms for self-defense. If the fundamental right of self-defense does not protect Caetano, then the safety of all Americans is left to the mercy of state authorities, who may be more concerned about disarming people than about keeping them safe. So, all right, so we went through the per curiam, and then we went through Alito's concurrence. I would say, while I normally hate Alito, he knocked it out of the park on this one. I thought it was a very good concurrence. He talked about specifically where they deviated from the concepts that we learned in Heller, or sorry, not learned. I'm trying to think of the word for it. That were developed in Heller. Sorry, the precedent that was developed in Heller. My bad, guys, my bad. Brain fart. But okay, so I think he did a good job of pointing out where they went wrong. And I think for me, I think this is one of those cases that not only you can see a lot of tie-in on how Heller and McDonald build a foundation for this case, but you can also see a trajectory. That's the biggest part for me here. You can see a trajectory, because I want to talk about what they were saying. Like, it has to be dangerous and unusual. In common use is a big thing. So I think when we see mag bans, potentially AR bans, I don't think this is going to turn out the way a lot of people want it to turn out. And it's because of the precedent that's been built while nobody has been watching. Now, people watch bigger cases, but a lot of times what they do is they're going to read through like a NBC article, and they're going to think that they have all the details. The opinion of the court, even sometimes concurrences, can be very important in seeing the trajectory of where this court is going to go. This is why I say, like, when people bring up things like banning ARs, it's not a pro or against thing. Like, my feelings don't factor in here. I don't believe it can be done on the precedent we already have built. I don't believe that if the Supreme Court were to take that case, whether we like it or not, I don't believe that the Supreme Court, if they were to take that case, would ever effectively be able to look at that precedent and say, nah, we're banning them. I just don't think that that's where it will go. And this, like I said, this is built on cases you're not reading and you're not watching. People come up a lot and they think they know all the details of it. Please go read through the rulings. I know this is a shorter ruling. I'm about to end. I'm sorry, I'm waxing poetic right now, or whatever. But I just want you to understand that what we saw in Caetano is an ultimate, like, sort of apex here. We've seen a build of McDonald and Heller and how they apply, and also how to look at them. When lower courts are looking at them and interpreting them, well, okay, like, where are we doing this at? On Monday, we're going to do Bruin. And Bruin's going to give us, or really flesh out, I should say, the text, history, and tradition text. If there's one live of mine you absolutely need to come to, it's the Bruin one. But Caetano has kind of given us where we're probably going to go with mag bans, AR bans, things like that. So it's something I want you to keep in mind, how these cases build on each other. Bruin we're going to be doing on Monday, and then we'll be doing Rahimi on Wednesday, because that kind of, I mean, not in a bad way, but it kind of like rolls back a little bit of the stuff with Bruin overall, because it's kind of like, you know, he's a real fucker. Like, you know, it says, you know, like, it's not written in amber. Some people didn't think the court was going to do it. Some people did. But yeah, we're going to be doing Bruin on Monday. Bruin is a big one. Bruin's a couple of hours. So get your popcorn, get ready to go. We'll start at 10 o'clock on Monday, as long as I'm not running late for whatever reason. But I know these are smaller lives, and if you have anything you want me to cover, please send it to me in a DM. I'm always happy to look, but we got to get together so I can like actually focus up and see like what do you want me to talk about? What are the specifics you want me to cover? But I'm gonna go ahead and end because I'm still sniffling. I'm still getting over cold and allergies and all that crap. But I'm so happy to have all of you here. Remember, these cases build on each other. And also remember, we're going to be going over Bruin on Monday, and that I love and appreciate every single one of you. It is going to be 9:00 Mountain Time, Colorado. All right, guys, I will talk to you all later. Thank you so much for being here, and I appreciate each and every one of you so freaking much. Y'all are amazing, and I love you. And have a good night, guys. Bye.